You're Christopher Bushnell?
Yes, ma'am.
So, Mr. Bushnell, you were previously in court, entered pleas of guilty to the third-degree felony offense of evading arrest or detention with the use of a vehicle, and the second-degree felony offense of engaging in organized criminal activity. Those were for agreements of a 10-year probation deferred in each of those cases. I have received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor. Everyone.
Are there any additions or corrections to the report?
Just that it may indicate that he.
2 deferred 10-year probations were supposed to keep a 17-year-old out of felony convictions. Then the judge pulled the jail file. What looked like mercy turned into a full audit on maturity, rule following, and public safety. The moment she linked his in-custody behavior to the danger he posed outside with guns, everything flipped. Source CourtCam TV.
Jail incident reports, have you both been given a copy of those?
Yes, Your Honor. I have him.
So you're 17 now?
Yes, ma'am.
December 26th.
The tone shifts the second jail incident reports are mentioned. Defense insists he takes full responsibility, but paperwork doesn't lie. Judges read patterns, not promises. If that incident log is thick before sentencing, it's a preview of probation failure. This is where deferred starts to die.
December 26th.
And Judge, if we need to go back and renegotiate an offer, obviously he's not even out of custody yet.
Yes, he's 17, almost 18. Defense wants a path to adulthood without felony scars. The judge might have agreed if his conduct backed it up, but age earns consideration, not immunity. When you're asking for community supervision, your behavior in custody is the audition, and he's flunking it.
Okay.
You cannot. 21 incident reports since January 25th of this year. 21.
21 incident reports since January 25th. Fighting, bullying, stealing food, disrespecting staff. That's not teen impulsivity. That's a sustained refusal to follow rules in the most structured environment he'll ever see. If he can't obey in jail, why would he obey on probation in the community?
Follow rules in the jail. What makes you think you're going to come in here and I'm going to say, sure, go be on probation out in our community? After y'all shot gun, I mean, this is serious. I'm tired of the shootings. I'm tired of people. You could have killed somebody. And because you accidentally didn't kill somebody, you get to get a probation. Not today.
The judge connects dots. Jail noncompliance plus gun charges equals unacceptable risk. Her line is brutal honesty. Accidental non-fatal outcomes don't earn probation. Gunplay doesn't deserve second chances. Courts are done rewarding lucky outcomes when someone could have easily died.
If I could send you to ISF, I would consider it. I can't. At this point, I'm going to reject the plea agreements. We will set the cases for a review in about 30 days. Let's see where we are, go over his options, y'all talk. If I can always do, upfront time, but we've got to get to a certain point where that would make sense. And so at this time, I'm just going to reset the cases. Again, I'm rejecting these plea agreements. And let me tell you.
Hammer drop. Plea deals rejected. Cases reset for 30 days. Translation, prove growth now. No new write-ups, no reports or prepare for trial and exposure up to 20 years. That cool-down window is his last off-ramp before prison. Smart defendants treat it like oxygen.
You get more of these, it's only going to get worse. I'm going to see them. A jury's probably going to see them if you, not probably, a jury will see them if you go to trial. And you're going to end up in prison for up to 20 years because you can't follow the rules in our jail and you're acting like a little punk. So go stop acting like a punk, prove that you can behave, then we'll see what happens. When you come back next, I'll see how many of these I have. Go back with the bailiff.
Then the viral moment, stop acting like a little punk. It's not insult, it's triage. She's naming the real problem. Bravado, defiance, no impulse control. Her challenge is simple: show discipline for a month, come back clean, keep stacking reports, and a jury will see every one of them.
Kimler? Yeah, on Mario Blunt. That's a sentencing.
Judge, I've spoken with the probation officer who's here, and I'm just going to ask the court to follow her recommendation. The one allegation that would have been proved up is a misdemeanor assault from last year that was never filed by the police department.
Okay.
It looks like we don't need to proceed on that.
So it looks like the recommendation is substance abuse.
ISS, or substance abuse ISS.
Well, it actually says substance abuse cognitive, and we can't do both. So
Is there one more than the other? Understanding that the problems are both cognitive and drug related. In your opinion, what do you think is best?
Cognitive first with JCBI aftercare.
okay, that would make sense.
And so that would be I understand it's in an agreement, I don't think, but this is what we're asking the court to do based on the pleas that have been entered in the probation's report.
I guess you're on the record. In talking with Mr. Blunt, I think that he will do, obviously he's not gonna refuse ISF. He was going to suggest that he's using, or has used marijuana or THC in the past to cope with anxiety issues in lieu of ISF to perhaps try to pursue something through MHMR.
Well, he didn't just use THC. He also used methamphetamine, and I'm pretty sure that's not very good for anxiety.
Different defendant. Next, new energy. Here, probation and prosecution both recommend ISF with a cognitive track, not just drug rehab. Because the real issue isn't THC for anxiety, the file shows meth. The judge makes it clear thinking errors come first, treatment second, freedom last.
Clause number 15-21380, I'm going to find that you entered your pleas of true to counts 2 and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that. I'm going to follow the recommendation of the district attorney and probation and continue you on probation in order that you enter and successfully complete the cognitive track of the ISF program. And then when you're released, you will enter and successfully complete the JCDI program. These programs are doing two different things. The first one is to help you make better decisions. It's about thinking and making better decisions. The JCDI program is the drug intervention program to help you with what you need, hopefully, to stop using drugs. So you're going to have all the tools that you need to make these better decisions, and then it's going to be up to you. Continue doing everything you're supposed to through your treatment and other things like that. It sounds like that hasn't been an issue. You're still on a deferred probation. You're still not convicted of this offense. If you're back in here again, in all likelihood, you will be convicted and you will be going to prison for a very long time. Do you understand?
Yes, ma'am.
All right. Good luck to you, sir.
Thank you.
Thank you, Your Honor.
Final outcome, probation continued with ISF, cognitive, and JCDI on release. 2 tracks, 2 goals, fix thinking, then fix using. One more slip, and deferred vanishes. Conviction enters. Prison up to 20 years. If you think the judge was right to kill the teen's deal but still engineer rehab for the other defendant, drop your take below. For more sharp, unfiltered courtroom breakdowns, like, comment, and subscribe.